بسم الله الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه ثم أما بعد. So today we'll continue al-Qawaaid al-Fiqhiyya, and if you remember from the last 3 times we've talked about the definition, subject matter, and some distinctions between al-Qawaaid al-Fiqhiyya and other related sciences such as al-Qawaaid al-Maqasidiyya, al-Qawaaid al-Usuliyya, al-Nazariyat al-Fiqhiyya, al-Madarik, al-Dawabit, etc. And today inshallah we'll go over the divisions of al-Qawaaid al-Fiqhiyya. And we're still talking about the sort of the 10 introductory principles that will give us good conceptualization of al-Qawaaid al-Fiqhiyya. Today we will talk about the divisions of al-Qawaaid al-Fiqhiyya, which is al-Aqsam al-Qawaaid al-Fiqhiyya. We will talk about the topics, al-Masail, and we will talk about al-Istimdad, or the sources. These are the things that we will talk about today. Imdad, or the sources of al-Qawaaid al-Fiqhiyya. So let's start with the divisions of al-Qawaaid al-Fiqhiyya. And basically when we talk about divisions, I just wanted to give you an idea of why the divisions are important. Why is it important for us to understand the divisions? Because the divisions are part of the definition. So it may seem that we're taking too long to define al-Qawaaid al-Fiqhiyya, but the divisions are still considered to some extent a part of the definition. Remember when we talked about definitions last time? The first time we talked about definitions, and we talked about the difference between the nominal definition, which is a lafzi verbal definition. Like what is al-Qadhanfar? Al-Asad. So just 2 different names for the lion. One name may not be as popular as the other, so you will explain one by the other. That's just a nominal definition, and this is usually not addressed in logic. But in the other definitions would be al-Hadd and al-Rasm. Some people may have like sort of other definitions, but included under Rasm. Al-Hadd would be the real definition. And we said that al-Hadd would be when you have the genus and differentia, when you have al-Jins and al-Fasl. Al-Insan Hayawanun Natiq. The human is a rational animal. Genus, animal, Fasl, Natiq, rational. And then we said that there is the descriptive definition. And the descriptive definition, there are classifications. There is tam and naqis, complete and incomplete. But genus and property, we said it's genus and property. And genus and property would be al-insan hayawanun dahik, al-insan katib, for instance. So when you say that a laughing animal, or an animal that has the potency to write, or writing animal, but eventually not every human can write, but by human has the ability to write by potency, not by actuality. Anyway, so that's called the, under Rasm also, you could say taqsim, classification or categorization, tamthil, exemplification. That is when you say that, like taqsim, particularly taqsim could be very helpful if it's exclusive. Like when you say, كلامنا لفظ مفيد كاستقم واسم وفعل ثم حرف الكلم, which means our speech is basically comprehensible prepositions or statements. كاستقم, like استقم, be straight. That is a speech that is comprehensible, that is mufid, that's beneficial. واسم وفعل ثم حرف الكلم. When you say that al-kalam, the speech or words, are either ism, that is noun, fa'al, that is verb, harf, that's particle. Ism, fa'al, harf. Noun, verb, particle. Is there anything else other than ism, fa'al, and harf or kalam? No, there is not. This particular type of classification is extremely helpful because it's exclusive. And it is, all inclusive and all exclusive, because there is nothing beyond اسم الفعل الحرف that would be kalam, and all kalam is اسم الفعل الحرف. So that's taqsim. And tamthil basically is to give examples. You try to define something, you give examples of what is the masadiq, the denotations, what it denotes outside in the reality. So you give examples, this. So that's definition by example. And then there is definition by similitudes, which is weaker. But anyway, so let's talk about the categories of al-Qawaaid al-Fiqhiyya, or the divisions of al-Qawaaid al-Fiqhiyya. And there is the basis of classification is important. So there are, we will mention just 4 bases of classification for al-Qawaaid al-Fiqhiyya. One of them is comprehensiveness. And the other one would be comprehensiveness, the source, the agreement. Not quite sure, agreement. I put agreement as the second one or the third one. And then the source, the istimdad. And finally, the scope or the field of operation. It's a more contemporary way of classifying al-Qawaaid al-Fiqhiyya. So what do we mean by comprehensiveness? Comprehensiveness. So al-Qawaaid al-Fiqhiyya, when it comes to comprehensiveness, would be divided into do you remember Imam al-Mardawi said that the difference between al-Qawaaid al-Fiqhiyya and al-Dawabit al-Fiqhiyya, regulators and maxims? Al-Qawaaid al-Fiqhiyya would cross chapter lines. Al-Dawabit al-Fiqhiyya would not cross chapter lines. They pertain to specific chapters. But al-Qawaaid al-Fiqhiyya themselves, even after they cross chapter lines, you have like al-Yaqeen la yazul bil-shak, certainty is not overruled by doubt, crosses all lines. So al-Qawaaid al-Fiqhiyya, after we separated the al-Qawaaid al-Fiqhiyya from al-Dawabit al-Fiqhiyya, al-Qawaaid al-Fiqhiyya among themselves, they're also different in terms of their applications. So you have, as we said before, al-Qawaaid al-Fiqhiyya al-Kulliyya al-Kubra, and I will call the other ones as-Sughra, and I'm just going to succumb to it, and the other one is Sughra, the minor. So major and minor. So you have the major and the minor. And the major ones are the 5 that we mentioned before, and I'll keep on repeating them until you remember them, even if you're not reading the notes after you go home, which you should be. But I'll keep on repeating them. One is al-Umur bi-Maqasidha, which means matters are judged by their intentions. The second one is al-Yaqeen la yazul bil-shak, certainty is not overruled by doubt. The third one is al-Darar yuzal, harm is to be removed. The fourth one is al-Mashaqqa tajlib bil-Taysir, hardship begets facility. The fifth one is al-Aada muhakkama, custom is authoritative. Custom is authoritative. And some people would add al-A'mal awla min al-Ihmal, which means application is preferred to dismissal. Application is preferred to dismissal, and some people will just say they are 5. Most of the people say they are 5. Most of the people will say they're 5. These are called the major ones. Then you have the minor ones, and the minor ones are further divided into dependent and independent and independent. Which, dependent, I mean by dependent, they are branches, they are subsidiary to the major ones. So the minor ones are either subsidiary to the major ones, or they are completely independent. Can I give you examples of both? Yes. So what would be a good example on a minor one that is dependent? And that is for, do you remember al-Ibra, al-Uqud, bil-Maqasid, wal-Ma'ani, la بالألفاظ والمباني. العبرة would be consideration, العقود in the contracts, المقاصد by intentions, المعاني meanings by intentions and meanings, لا not by alfaz, words, and mabani forms. So consideration in contracts is given to intentions and meanings, not to words and forms, not to words and forms. So where does this belong? It belongs under the first major legal maxim, which is al-umur bimaqasidha, which is matters are judged by their intentions. So it is dependent on it. The same applies to الضرورة تقدر بقدرها, which means that necessity is judged by necessity is considered or judged by its extent. This is a subsidiary maxim. It is a branch of المشقة تجلب التيسير. Hardship begets facility. Some people will consider it a branch of الضرر يزال. Harm is to be removed. Could be either this or that, but it is dependent. So what would be independent legal, independent minor ones? We mentioned, for instance, التابع تابع. التابع تابع. تابع is what? Secondary, subsidiary, secondary. تابع means what? It means it follows the principle. The subsidiary follows the principle. The subsidiary assumes the ruling of the principle, or the subsidiary follows the principle, or the primary. Secondary follows the primary. So if you have secondary clauses in a contract, they follow the primary, and then based on this, there will be many maxims that we will discuss that will address this concept, that there is a difference between the principal subject matter of the contract, the principal, basically intent of the contract, and the subsidiary or the secondary clauses in a contract. They will have different rulings, and there will be more leniency shown to a taba than the principal, to the secondary than the primary. We've talked about al-ijtihad la yunqad bil-ijtihad, which means that ijtihad is not invalidated by another ijtihad. Ijtihad is not invalidated by another ijtihad. So that is also independent. You can't fit taba under one of the five. You can't fit ijtihad is not invalidated by another ijtihad under the five. They are independent, and in fact, they have subsidiary maxims that are dependent on them. Okay, so this is basically the classification of al-Qawaaid al-Fiqhiyya when it comes to comprehensiveness. How about the classification of al-Qawaaid when it comes to agreement? Well, basically be just two divisions, but not, the second division would be further subdivided. This would be agreed upon. Agreed upon. So there are qawa'id that are agreed upon between the mazahib. The five legal maxims are agreed upon, yes. They may agree on application, but they are agreed upon in principle. They are five legal maxims. Disputed qawa'id. There are disputed qawa'id, of course. So I gave an example, an important example on the disputed qawa'id. And I wanted to make this division here and say inter-madhabi and intra-madhabi disputation. Inter and intra-madhabi disputation. What do I mean by this? Take, for example, the inter-madhabi disputation. This principle that we just talked about, al-ibra fi al-uqud bil-maqasid wal-ma'ani la bil-alfaz wal-mabani. Consideration in contracts is given to intents and maqasid, intents and meanings, not words and forms. Is this a controversial concept? Yes, to some extent it is a controversial concept. So you will find it more consistently applied by the Hanafis and Malikis. You will find that less consistently applied by the Shafi'is and Hanbalis. However, to be exact, the Hanbalis are much closer to the Hanafis and Malikis in this regard than they are to the Shafi'is, who favor forms over intents. And, just to be fair to the Shafi'is, I want you to understand why they favored forms over intents, because they were thinking at it from the judge's perspective. And from a judiciary or judicial perspective, I'm not going to get into intentions and meanings. What I care about is forms and words, because as a judge, someone comes to me with a contract, but anyway, the majority would say when there is something to expose or disclose this. Of course, I'm not going to be reading hearts and minds, but when there is something to expose the intention or to disclose the intention, I'm going to go by it. So that's why the majority would say, where intents and meanings are given precedence or are favored to words and forms. So it's a little bit of a controversial qaida or principle. What about intra-madhabi qawaid? I just give you one example in the notes from the Hanbali madhab, and usually in the madhab, when they talk about a qaida that's controversial within the madhab, they make it in the form of a query. Hal is hal al-ifraz. I'm sorry, hal al-qisma. Okay, let me try to do this carefully here. Okay. هل القسمة إفراز أم بيع? Is division an allocation or sale? Is division an allocation or sale? Okay, what do we mean by this? We co-own a property. And now we just want to separate like my portion from your portion. Now, what is this division? When we divide the property and I take my portion, you take your portion, is this just simply allocation or a sale? Because we co-owned it, I am selling you the part that will be yours, you're selling me the part that will be mine. Is this consequential? Legally, it is very consequential. So we will come to it. But for now, just know that this is phrased in the Hanbali madhab in the form of a query. Is division an allocation or sale? Okay. So now we've done with the second basis of classification. What would be the third basis of classification? The third basis of classification would be the source, and we will come to talk about the source in more detail later. I will go briefly over it here. The source of al-Qawaaid al-Fiqhiyya will be textual or derived, and we will come to talk about this later. Simply and quickly, textual would be the qaida itself is a text from the Quran and Sunnah. The text from the Quran and Sunnah, or like an adaptation of a text from the Quran and Sunnah, like a slight adaptation of a text of the Quran and Sunnah, would be the qaida. So what is the first qaida? Al-Umur bi-maqasidha, which means matters are judged by their intentions. This is basically, some people use al-a'mal bin-niyat as the qaida. Actions are but by their intentions as the qaida. And some people use al-umur bi-maqasidha. But if you use al-umur bi-maqasidha, this is basically an adaptation of al-a'mal bin-niyat, which means actions are but by their intentions. And when you have some people use al-darar yuzal, harm is to be removed as the qaida. Some people use la darar wa la dirar itself as the qaida. La darar wa la dirar, no harm, there should no harm or reciprocation of harm, which means there should be no harm or reciprocation of harm, means is a hadith of the Prophet sallallahu alaihi wasallam. So the hadith itself is the qaida or a slight adaptation of the hadith. These are called textual qawaaid. They are more powerful than the derived qawaaid. And the derivation of the qawaaid, as we will come to see later, could be basically derivation from nusus, from the text of the Quran and Sunnah, or derivation from the inductive examination of the body of fiqh, And you can have like here, for instance, a derivation that is from the Quran and Sunnah. When you say al-yaqeen la yazul bil-shak, or certainty is not overruled by doubt, can you find like proofs on this, like from the Quran and Sunnah, right out of the Quran? Of course, إِنَّ الظَّنَّ لَا يُغْنِي مِنَ الْحَقِّ شَيْئًا, which means that conjecture does not avail anything against the truth. Conjecture does not avail anything against the truth. This would be the basis. And more clearly, when the Prophet ﷺ says, إذا وجد أحدكم في بطنه شيئا فشك هل خرج منه شيئا أم لم يخرج فلا ينصرف من مسجده حتى يسمع صوتا أو يجد ريحا. When someone finds something, when feels something in their stomach and they're in doubt whether something came out or not, they shouldn't leave the masjid until they hear something or smell something. What is the Prophet ﷺ trying to do here is trying to address people with OCD, obsessive people. You go by certainty. Don't basically get frazzled by doubts. Go by that which is certain. اليقين لا يزول بالشك. So that's basically the third basis of classification of al-Qawaaid al-Fiqhiyya. What would be the fourth basis of classification of al-Qawaaid al-Fiqhiyya? And this is very simple and straightforward. It's basically the scope. You may get confused between the scope and the comprehensive. And maybe I should try to find like a better translation for this. But I'm talking about majal al-amal, or field of operation of al-Qawaaid al-Fiqhiyya. So contemporary scholars may take al-Qawaaid al-Fiqhiyya that pertain or belong to a particular subject, or a particular concept, and separate them. So we have people separating Qawaaid al-Fiqhiyya that pertain to facilitation in Shariah. We have people who separate al-Qawaaid al-Fiqhiyya that pertain to medicine, medical practice, bioethics, contracts, for instance, or financial transactions. You separate the Qawaaid al-Fiqhiyya that belong to financial transactions or medical practice, bioethics, or this, that. And, these are, sciences develop, and that is fine. And when you author on al-Qawaaid al-Fiqhiyya that pertain to a particular discipline or a particular subject matter, that's absolutely fine. That's it for the classification of al-Qawaaid al-Fiqhiyya. Now we will move on to istimdad al-Qawaaid al-Fiqhiyya, or the sources of al-Qawaaid al-Fiqhiyya. And as we said, نسبته وفضله والوضع على اسم الاستمداد وحكم الشارع على اسم الاستمداد وحكم الشارع. الاستمداد, which means the sources of the discipline. So that's something that is important to understand. What are the sources where al-Qawaaid al-Fiqhiyya come from? And we've basically alluded to this in the past, but we will talk about this a little bit in more detail. I'm sorry, but maybe before the istimdad, we'll go over the masail, the topics, which is very brief. The topics of al-Qawaaid al-Fiqhiyya, the table of contents of the book, and the topics of al-Qawaaid al-Fiqhiyya, I give you like a definition for مسائل العلم قضاياها أي القواعد الباحثة عن أحوال الفروع من حيث التطبيق والاستثمار. So it basically, what are the masail of, or the topics of al-Qawaaid al-Fiqhiyya? The propositions of this discipline, i.e. the principles that investigate the conditions of detailed legal rulings in terms of application and derivation. So the table of contents, and that is what we will be talking about for the rest of this class. We will be talking about the Qawaaid al-Fiqhiyya. We'll be talking about their meanings, their evidences, their conditions, their branches, and their exceptions. And now let's go over the sources of al-Qawaaid al-Fiqhiyya. So as we said, and this will be a repetition, but that's fine. The first thing is you get Qawaaid Fiqhiyya that are sourced from the Quran and the Sunnah. Sourced from the Quran and Sunnah. Could you say إن الظن لا يغني من الحق شيئا is a qaida? You know, conjecture does not avail against the truth. Yes, you could actually say that. اليقين لا يزول بالشك إن الظن لا يغني من الحق شيئا. But there are Qawaaid Fiqhiyya that are coming verbatim from the Prophet sallallahu alaihi wasallam. As we said, you know, you could use al-a'mal bin-niyat instead of الأمور بمقاصدها. So actions are but by their intentions, matters are judged by their intents or their intentions. That is, you know, that is one of the 5. الضرر يزال, harm is to be removed. You know, no, actually, like if I'm getting the hadith should be لا ضرر ولا ضرار. Okay. So لا ضرر ولا ضرار. There no harm, darar is harm, and no reciprocation of darar is harm. And we said before, and we will come to it, and we'll talk about, you know, the many interpretations that people gave to the darar and dirar. So al-qaida that is famous is darar yuzal, but many people use la darar wala dirar as the qaida. Many people use darar la darar wala dirar as the qaida. So what else you can say here? You could say al-Kharaj bid-daman. Al-Kharaj bid-daman. So this is the hadith and the qaida. Profit, al-Kharaj is profit. Bid-daman is linked to or hinges on or follows liability. So, and that is one of the major principles in financial transactions in Islam. There is no, it's like, what is it? No pain, no gain? Is that what they say? Okay, no pain, no gain. Profit follows liability. The other formulation of this al-qaida is called al-ghunm bil-ghurm. Al-ghunm bil-ghurm. Which means al-ghunm is gain, ghurm is risk of loss. Risk of loss. You would say loss, but it means risk of loss. Al-ghunm bil-ghurm. So gain is linked to the risk of loss. So that's why in Islam, riba is not halal. Money does not beget money. Money does not beget money. You will have to take some risk to make a profit. You will have to take some risk to make a profit. But to make a profit without taking any risk would not be acceptable. And you could mitigate the risk as much as you can. And that, you know, a good businessman would try to mitigate the risk as much as possible. To diminish the risk, it's, you know, Islam does not ask you, basically, in fact, on the opposite side, Islam doesn't want excessive risk-taking because that would be called al-gharar. Gharar is excessive, undue risk-taking, which is like gambling. Gambling is excessive risk-taking. That's al-maisir. Maisir is in play. Al-gharar is in transactions. So Islam forbids both. Forbids gambling in play and the gharar or qimar, maisir, in play, that is gambling, and forbids the gharar in transactions, which is undue risk-taking. And You know, there's so much that can be said about this, but we will defer to when we come to it. Anyway, and then you have al-bayyinatu ala man idda'a ala man idda'a. Okay, whatever. Yamin ala man ankara. Okay, al-bayyina means what? The burden of proof. Al-bayyina means the proof. Here it means the burden of the proof. Ala, upon, man idda'a, the claimant, he who claims, he who claimed, the claimant. The proof, the burden of the proof is on the claimant. وَالْيَمِينَ عَلَى مَنْ أَنْكَرَ. Al-yamin, the oath. Ala, upon, man ankara, he who denied. So you translate this as what? The burden of the proof is on the claimant, and the oath is on the denier. That's how we translate this. This is the hadith, and it is the qaida, and it is such a powerful qaida, an agreed upon qaida, a powerful qaida that has many applications in the judicial system. The claimant has to produce the proof, and the denier, so we have the status quo. We're going by the status quo. Al-asl baqa' ma kan ala ma kan. That's the status quo should be the default. And then anyone who claims other than the status quo has to produce a proof. Anyone who denies a change from the status quo needs to take an oath. Only needs to take an oath. Okay, so these are Qawaaid Fiqhiyya that are derived from the Wahy, from the revelation. You have another type of Qawaaid Fiqhiyya that are indicated by the Wahy, not basically sourced directly from the Wahy. They are indicated by the Wahy. And we've talked about al-yaqin la yazul bi-shakk before. We can also mention hardship begets facility. Does hardship begets facility, this qaida, come out of al-wahy directly? Not necessarily, but it is indicated by al-wahy. وَمَا جَعَلَ عَلَيْكُمْ فِي الدِّينِ مِنْ حَرَجٍ. He has not placed upon you haraj in the deen. Haraj is hardship. Haraj is distress and hardship. So hardship and distress are not prescribed in our deen. وَلَا يُكَلِّفُ اللَّهُ نَفْسًا إِلَّا وُسْعَهَا. Allah does not basically burden a soul beyond its capacity. So haraj is not prescribed in our deen. Therefore, you could say that al-mashaqqa tajri bit-taysir is indicated by the wahy. Is indicated by the wahy. And when we talk about indication, we're talking about a clear indication, because everything at the end of the day will need to be indicated by the wahy. Somehow. But we're talking about a clear indication here. Now you have maxims that are sourced from consensus. There are certain maxims that are sourced from consensus. For instance, when it comes to إن الماء طهور لا ينجسه شيء إلا ما غير لونه أو طعمه أو ريحه. This is the hadith. The second part of the hadith is da'if by consensus, is weak by consensus. The hadith says, verily water is pure, and nothing will render it impure except that which changes its color, smell, or taste. Its color, smell, or taste. That is a hadith. From the second portion of the hadith, from illa, except that which changes its color, smell, or taste, this part is by consensus da'if. By consensus not traceable to the Prophet ﷺ. However, it's a matter of consensus. So, and we talk about hadith in the second class, but maybe it's not a bad idea to mention this here. Should you say that this hadith, that the whole hadith is hasan or acceptable just because there is consensus on the meaning of the second part? No, you should not. You should not. You should still say that this portion is weak, but the meaning of it is sound by consensus. معناه صحيح اتفاقا إجماعا. So its meaning is sound by consensus, but you should still say this portion is weak. When will this portion be elevated to like sound or even صحيح? If you have shawahid or concurrences. Shawahid would be corroborations. Many Sahaba related this, and the chains are not too weak, so they can corroborate one another. Many Sahaba related the same meaning, or the same meaning was related from different Sahaba, different change of narration, and the chains are not too weak to not be able to corroborate one another. But anyway, so we have another one that is not part of a hadith. Al-ijtihad la yunqad bil-ijtihad, which is a huge qaida. It is a huge qaida for us that we will come to talk about in much detail, and this would be very helpful for the students of knowledge in particular. It means ijtihad is not invalidated by ijtihad. So the ijtihad of Abu Hanifa is not invalidated by the ijtihad of Shafi'i. The ijtihad of Shafi'i is not invalidated by the ijtihad of Malik. And, sometimes they say that the ijtihad of Malik is not invalidated by the ijtihad of Malik, which is another discussion that we will get to. The ijtihad la yunqad bil ijtihad. Ijtihad is not invalidated by ijtihad. Is an important qaida. Where is this in the Quran and the Sunnah? So it's very hard to find like anything that would refer to infer this directly. But we have known from the, you could say that the Prophet ﷺ did not basically rebuke any of the Sahaba when he sent them to Bani Qurayza, and he said you should not pray Asr except in Bani Qurayza. And the Sahaba disagreed among themselves, and some of them said that the Prophet ﷺ meant that we should hasten to Bani Qurayza, and he did not mean that we should miss al-Asr. So, when Maghrib was approaching, they prayed. They said he just meant that we should hasten to Bani Qurayza. And the other Sahaba said, no, the Prophet said, don't pray Asr except in Bani Qurayza. So we will not pray Asr except in Bani Qurayza. And the Prophet did not rebuke any of them. But, more clearly, all the ijtihadat of more clearly, the ijtihadat of Abu Bakr were not invalidated by Umar. And the ijtihadat of Umar were not invalidated by Uthman, and so on and so forth. Even the ijtihad of Umar himself, Umar radiallahu anhu made two different ijtihads when it comes to particular mas'ala of inheritance. And when they told him, this is not how you judged in this matter last year, he said, تلك على ما قضينا وهذه على ما قضينا. That was in accordance with what we have decreed or judged then. This one is in accordance with what we have decreed now. So certainly, laws change because you come to know different things, and the mujtahid may change his mind. Does that mean that we will be going back and reversing all the rulings? No, that would lead to chaos and instability in the judiciary. So when the law changes, everything that preceded will just stay as is, and then we will just move on from here onwards. And that is the meaning of al-ijtihad, la yunqad bil-ijtihad. And then we have qawa'id that are sourced from reason. So far we have said they are text, they are indicated by the text, they are matters of consensus, and then you have qawa'id that are sourced from reason. There are, when you say al-awla min al-ihmal, which means application is preferred to dismissal, any reasonable person would disagree here. applications prefer the dismissal. That applies to people's speech and people's actions. So when you are examining a particular scenario or a particular case, application of all the data takes precedence, is preferred to dismissal of, or disregard of some data that you have. That should be just like sourced from reason. You know, reasonable people would agree. إذا زال المانع عاد الممنوع. When the restriction is removed, the restricted returns. When the restriction is removed, the restricted returns. You know, يثبت الحكم بثبوت سببه. You know, a ruling is established when its legal basis is established. When its legal basis, the sabab, or the effective cause, or legal rationale is established. Does that make sense? Of course. You know, the musabbab, the cause follows the sabab, the cause. The effect follows the cause. Okay, so these are basically legal maxims that are sourced from reason. And then you have legal maxims that are sourced from language. Language. What would be some legal maxims that are sourced from language? المطلق يبقى على إطلاقه ما لم يقيد, which means the absolute remains absolute until it's qualified. The absolute remains absolute until it's qualified. What would be another one? السؤال كالمعاد في الجواب, which means that the question is implied in the answer. When you say, when I say to you, are you writing now? Okay, he just said yes. Did he say anything else? What do you, yes is, yes what? It's meaningless. But unless my question is implied in his answer, this yes will be nonsensical, useless, right? So السؤال معاد في الجواب. The answer is implied in, the question is implied in the answer. And this is basically simple language. You know, anyone who heard this conversation between me and him would understand that he said, yes, I am writing now. Then we have qawa'id that are sourced from the statements of the companions, sourced from statements of the companions. Such as Umar is saying, رضي الله عنه, مقاطع الحقوق عند مقاطع الحقوق عند الشروط, which means that, okay, so the rights are subject to conditions. Rights are subject to conditions. Is that how I translated this here? The settlement of rights is subject to the conditions, yeah. Okay, and then certainly the Prophet ﷺ said, المسلمون عند شروطهم, Muslims abide by their conditions. And you could say that the statement of Umar is based on this. Yes, of course. Eventually, ultimately, everything will have to be based on wahy, or the revelation, the Quran and the Sunnah, because that's our ultimate source. Okay, and then you have statements of al-A'imma al-Mujtahideen, mujtahids. You have statements of mujtahids. So Ibrahim al-Nakhai, for instance, said, you know, that every divorce initiated by the man, every separation initiated by the man is a divorce. So every separation initiated by the man is a divorce. You know, versus what, like khula', for instance, would be a separation that's initiated by the woman. But every, you know, separation that's initiated by the man is divorce. And then you have a statement like the statement of Imam al-Shafi'i, لا ينسب لساكت قول. لا ينسب لساكت قول, which means no statement will be attributed to someone who remains silent. Makes sense? Yes, no statement, nothing would be attributed. So silence does not mean anything, which is, you don't think that this is nonsensical. Don't think it's just like, no, it is very meaningful. That if you remain silent, nothing can be taken against you as long as you remain silent. Isn't that one of the, like, they apply this here in the law? Okay. لا ينسب لساكت قول. And then you have a statement of Imam Shafi'i also, إذا ضاق الأمر اتسع. When it gets tight, it gets loose. That means it should be loosened. You know, that's, you know, some other formulation of al-mashaqqa tajlib at-taysir, or hardship begets facility. Hardship begets facility. Now you have you have statements of Imam Ahmad. لا يترك حق لباطل. لا يترك حق لباطل. لا يترك should not be abandoned. حق, truth, or like a right. Batil is falsehood. And the way I translated this is, a right is not abandoned for a falsehood. A right is not abandoned for a falsehood. To contextualize this, Imam Ahmad said a right is not abandoned for a falsehood when someone said to him, like, I go to consult someone and I find him tearing up his clothes. You know, so he's committing haram, you know, he's falling in sin. Like someone bereaving a death in the family or something, you find them tearing up their clothes. Should I still console them? Imam Ahmad said to him, لا يترك حق لباطل. A right is not abandoned for a falsehood, which means that his engagement in falsehood should not prevent you from consoling him, because consoling him is right, is good. And then, you know, we find the statement of Imam Ahmad where he says, al-faridatu min al-mal wal-nafila min al-thuluth. When he was asked about someone who writes in their will that he recommends for his heirs in his will that they should pay zakat on his behalf or make hajj on his behalf. So Imam Ahmad said the obligatory hajj and zakah will come out from his entire estate. But if he recommended some nafila, something supererogatory, something that's not obligatory, to be done on his behalf, whether it is zakah, sadaqah be paid, or supererogatory hajj, sunnah hajj, to be done on his behalf, then it comes out of 1/3, because he has no control over his entire estate after his death. He has control over 1/3. And Imam Ahmad also said, you remember when we first started this series, we talked about Imam Ahmad saying to his son, قُلْتُ لَكَ الْأَبْوَالُ كُلُّهَا نَجِسَةٌ إِلَّا بَوْلَ مَا يُؤْكَلُ لَحْمُهُ. So I have said to you before, all urine is impure except for the urine of animals whose flesh can be eaten. And that is also a qaida. Why? Because it regulates the multiple applications. Now, so these are just statements from the Mujtahideen. There are maxims that are derived by jurists from, you know, the extensive study and inductive examination of the body of fiqh, the entire body of fiqh. And let's take some examples here. Ibn Rajab's 9th maxim, for instance, where he said that every ibadah or every act of worship that takes place in a haram manner, or, you know, the acts of worship conducted in a prohibited manner. Yeah, I guess. And this is a big, you know, subject of disagreement between the Hanbalis and other madhahib in one particular application. So you have an ibadah here, like prayer, for instance. So the prohibition, you know, you conduct your prayer in a manner that is prohibited, What does the prohibition pertain to? Does it pertain to the essence of ibadah? All of them will say your ibadah is invalid. Does it pertain to a condition? Then in the Hanbali madhab, this condition is either specific to this ibadah, such as facing the Qibla in prayer. this is a condition that is specific to this ibadah or not? Should you be facing the Qibla outside? No, you don't need to face the Qibla. It's specific to this ibadah. So if you're not facing the Qibla, your ibadah is invalid. But what if the condition to the prayer is not specific to the prayer? Such as what? Such as, for instance, الوضوء بالماء المغصوب الصلاة في الأرض المغصوبة. So to make wudu with usurped water, or to make a salah in a usurped place or house, or residence. What is this? Is this condition ibadah? It's not specific, because it's haram for you to use this usurped water. Any use of this usurped water is haram. Not just the wudu is haram. Any use of this usurped water is haram. So it's not specific to the ibadah. Then in this case, the prohibition does not apply to a condition that is specific to the ibadah. Is your ibadah valid or not? So most of the people will say valid. You did something haram, but your ibadah is valid. The Hanbalis, in their popular position, will say no, your ibadah is still invalid. Because, the very water that you used to make wudu was haram for you to use. Therefore, your wudu doesn't count, your salah doesn't count. The very space that you occupied in your salah, the very ruku' and sujood that you made it by occupying a space that is haram for you to occupy. Haram space. Like, let us say this room here belongs to Shariah, for instance, and I came and forcefully seized it, took it from him. And now I took that house from him and I stayed in the house. My existence in this hayyiz, in this space, is haram. So when I'm doing ruku', occupying that space itself is haram. Therefore, the whole thing is. But anyway, the majority, and also one position in the Hanbali madhab, will say that your salah is valid, but your occupation of the space is haram. So you'll earn a sin for the occupation of space, but your salah will be valid. There are, some other examples that you will find there. Maybe we'll just take one of them. كل دية تحمله العاقلة تجب مؤجلة وما لا تحمله العاقلة يجب حالا. So which means every blood money borne by the aqila, the male relatives of the offender responsible for the blood, is due over time, and what's not borne by the aqila is due immediately. So the aqila, the blood money means what? If you kill someone by mistake, you have to compensate the heirs, right? If you kill someone intentionally and the heirs decide to forfeit the right to equal retribution, they can ask for diyah. They can ask for blood money. But if you kill someone by mistake, you will not be killed. I mean, you just like driving your car and you just kill someone by mistake, or you're trying to shoot a deer and you kill someone by mistake, you should not be killed. But you will be responsible for compensation. This compensation is called blood money, it's called the diyah. This diyah will be borne by the aqila or the person. When someone kills by mistake, we should show some mercy to this guy, because it's just like such a tragic event. He was trying to hunt and he killed someone. It's such a tragic event. So we will say to his relatives, you should come and help this guy pay the blood money or compensate the family of the victim. Now, al-aqila, and this is something that we can talk about when it comes to like تغير al-fatwa, which we will come to it when we discuss al-'ada muhakkama. Custom is authoritative. Umar radiallahu anhu changed this aqila from the male relatives to the people in the same registry. The Hanafis and Malikis took the position of Umar and applied it. And, Shafi'is and Hanbalis did not. But anyway, that is an example on تغير الفتوى, the change of fatwa, based on the change of circumstantial variables. Because Umar felt that when, if I wait, people in the past used to live in Medina or used to live in one place, and I can bring all the aqila within, a few hours and tell them you're responsible for the blood money. But what if someone had already moved to Al-Kufa and their family in Yemen? Family is in Yemen. And also because, this became like an empire of faith where Islam spread. Some of the family may have been in Egypt, and some of the family may have been in Oman now, so you just never know. Some of the family may have been in India, not by the time of Umar, but shortly thereafter. So what do you do then? How do you bring all those people in? So Umar said the people in the same registry, the people in the same registry will be responsible instead of the male relatives. That is change of fatwa because of the change of the demographic realities, the socio-political realities of those times. Anyway, so that is al-aqilah. But the principle says that anything that is obligatory on the aqilah will be due over time. Anything that is obligatory on the offender will be due immediately on the offender. So that is like a principle that we apply. And there are many others that are basically extracted or extrapolated from studying the whole body of fiqh. So let's go back to just summarize. Okay. So al-istimdad, the sources, some can be just the exact text verbatim, some are indicated by the text, some are sourced from consensus, some are sourced from reason, some are sourced from language, some are sourced from the statements of the companions, the statements of the mujtahid, and the one that we have mentioned in the beginning is sourced from induction the entire body of fiqh. You examine the entire body of fiqh and you recognize, identify patterns. Once you have identified the pattern, you formulate that pattern into a qaida or a principle. And by this, we would have come to the end of this session, inshallah, and we will take 15 minutes off and come back at 9:15 for al-adab al-mufrad. قولوا قولي هذا واستغفر الله لي ولكم.